Good afternoon, everyone, and welcome to this afternoon's webinar. I hope everyone is warm, safe, and as healthy as can be during this third COVID wave that we're all facing. This afternoon, we will be discussing a topic which I think is front of mind for everyone, and that is the Protection of Private Information Act and exactly what you as a healthcare provider needs to know. While people are settling in, I can tell you that we had a tremendous registration response for this webinar. And I think there's officially over 1,400 people that registered. Unfortunately, seats are limited, so hopefully as many of you as possible can join us. We will, however, make this webinar available exactly the same as all our previous webinars. And you can find this on our YouTube platform. I will be sharing the link in just a second. We will also, straight after the webinar, potentially tomorrow or first thing on Monday, send out communication to all the attendees and even to the people who registered but couldn't get their way into the webinar. Now, there's a long list of different disciplines joining us this afternoon. Last count was, I think, over 21 disciplines. I can see a lot of familiar names, not faces, I wish, joining us virtually. Very, very welcome to each and every one of you. I can tell you that we had about 130 physios that registered, 340 psychologists. Wow, thank you for joining us. There's close to 80 biokineticians, 70 chiropractors, 50 orthotists and prosthetists. There's over 130 occupational therapists, a lot of social workers, around 50, and even over 100 speech therapists and audiologists. What we also did today is we extended the invitation to specialists and general practitioners. And I want to say a very, very and a special warm welcome to all of you. I noticed that we've got officially over 130 doctors registered with us this afternoon as well. For those that don't know me, my name is Lani Ace, and I'm a product manager with the SPECIFICATION Global Group. And you might know that both SPECIFICATION and ProfNet are some of the companies that form part of this group. Now, on the SPECIFICATION side, they provide practice management benefits and functionalities to our specialists and other doctors. And on the ProfNet side, they also provide practice management benefits and other functionalities to our other healthcare providers. And this include the disciplines like physios, chiropractors, speech therapists, social workers, nurses, etc., etc. The list goes on. Now, you might know that at the sort of later end of last year, ProfNet partnered with Shackleton Risk Management, Genoa Underwriting Managers, and with Sapphire. And together, those three organizations created a range of new medical professional indemnity policies for, if I may use the word, allied providers. In this case, it's all healthcare providers apart from the doctors and the dentists. Now, today we have two very knowledgeable guest speakers joining us this afternoon, both from Genoa Underwriting Managers, who kindly, together with Shackleton, agreed to open this invitation to literally anyone, and not just those healthcare providers who's insured with them. So thank you very much for that, both Genoa and Shackleton. If I may, first of all, introduce Jacqueline Smith. Now, Jacqueline, or Jax like we like to call her, is a claims executive, and she's an admitted attorney with several years of experience in the medical malpractice litigation area. And secondly, a very familiar face to us is Dr. Brad Byra, who's a chiropractor. He's the author of many a medical journal. And if that is not enough, he's also a medical legal expert. Brad and Jackie, thank you so much for joining us today, and thanks for making yourselves available.
Thanks, Lani. It's a pleasure to join you all.
All right, so I think most of the people have joined us already. I see there is still people coming in, but I don't want to waste any further time. It is nearly 5 minutes past 4. Let's tackle this concept of the POPI Act. And I think it actually might create different sentiments under healthcare providers at the moment. It can be considered daunting. It can be considered confusing, not important, and something that I can get to at a later stage when I've got time. But hopefully our two guest speakers today can shed some light on this and clarify whether you should be doing something about it, what it is that you should be doing, and also what the impact might be if you don't pay attention to the POPI regulations, which comes into effect on the 1st of July, which, if I'm not mistaken, is only 7 days away. Just before I hand over to Jackie and Brad, attendees, please remember, if there's any burning questions, please use the chat or the Q&A functionality, and we're going to try and keep an eye on those questions coming in. Now, Brad, I'm looking in your direction first. And you know, I used to be a healthcare provider myself, but I remember from way back when I was a student, it was sort of ingrained in you that you have to keep your patient's information safe. And I think it's literally part of every healthcare provider's DNA to keep patient information secure. Now, POPI started way back when in 2013, if I'm not mistaken, but how are all these new changes going to make a difference in our practices, and is it going to make a difference? Perhaps you can start, and then I know Jackie kindly prepared a presentation for us as well. Thank you.
Thanks, Lani. I always joke with Lani, and hi to everyone who's there, and I'm going to hand over to Jackie, who's much more experienced at the legal parts of this. I always joke to say, if you want a long answer, ask me a short question. So that was a short question, and in some ways it's not going to or shouldn't be changing at all. And Jackie will take you through. From the very first day that you got into doing your clinical work, you were told, take a case history, keep the notes, record everything. And if you remember, my first case history and patient intake forms had name, address, telephone number, fax number. It was before email addresses, and you added email addresses. And then you had your financial information, who should I bill? And then it became medical scheme billing. So all of those sections of what we did, your personal information, your billing information, your residential and location information, then your clinical information, we needed to keep. And we needed to keep that not only because we needed to know who the patient was, but because the National Health Act said so, and the Constitution, and Jackie will take us through that. But also we needed to know what diagnosis we had, what treatment we had, and so on. So that hasn't changed. What this new act does is it says, if you're going to consolidate information to look at your practice, for example, how many patients have I got by which age, race, gender, demographic, condition, treatment code, ICD code, procedures done. Once you start grouping that information together, that's special processing of the data. And that's something new. If you're then going to use the patient's information for teaching or for publications or to write a journal, now you need additional permissions and you need to handle that in a specific way. So I think, Lani, that's really what's new for us is, and we've hinted to this in informed consent over the last few years. If you're going to do something, you need to tell the patient what you're doing. If you're going to share their information, you need to do that in a way that they're aware, and you need to get written consent. So POPI really drives that consent process that we've been speaking about over the last couple of years into a more formal legislated structure. And whereas it's bringing the rest of industry into a point of managing consent, confidentiality and disclosure good, this is something we've already been doing to 95% of the requirement up until now.
I thought so. Maybe Jackie, you can take it a bit further, and I'm not sure whether you want to share the presentation.
Sure, Brad, if you don't mind doing that for us.
So the presentation shared on the screen.
There we go.
Hopefully you can all see it, and I'm going to be the navigator on Jackie's Safari.
Thanks so much. So yes, this piece of legislation, POPI, which was signed into law already in November 2013, with an indication from our president that he would determine when it would come into force and effect. Then by 2014, only certain provisions of the POPI Act had commenced, not all of them. However, the majority of these sections, and I'm talking about those that create these compliance requirements, they commenced on 1st of July 2020. And we were then given a 1-year grace period to comply with these sections, which takes us to the deadline date of 1 July 2021. So it's for this reason that everybody is rushing around to ensure that they are compliant. But the big question remains, why do we need POPI? Well, this is largely because consumers, including patients of healthcare services, are more aware of their rights now, and regard needs to be had as to how organizations and professionals handle patients' consumers' personal information. So let's begin by having a look at what the Constitution, the highest law of the land, says. There are certain rights under the Constitution which need protection. These are Section 14, which says everyone has the right to privacy, which includes the right not to have the privacy of their communications infringed. Section 32, everyone has the right of access to any information held by the state and any information that is held by another person that is required for the exercise or protection of any rights. Right, if you can just flick to the next slide. So how do we give effect to these rights under the Constitution? Well, there's a section of the Constitution that says, and that's Section 32(2), that national legislation must be enacted to give effect to these rights. And that is what the legislator has done here. They have enacted POPI so that we can give effect to these important rights under the Constitution. So to ensure that all South Africans and businesses, so I'm talking about private persons and businesses, conduct themselves in a responsible manner, we need to collect, process, store, share other information by holding ourselves accountable so that we do not abuse or compromise this information in any way. Brad, you can go. Aside from the Constitution, there has been, as Brad mentioned earlier, legislation that's been existing for a long time, which govern the healthcare sector. For example, the National Healthcare Act, which makes it an offence to disclose patients' information without their consent. The National Patients' Rights Charter, and this came about because South Africans previously didn't have access to proper healthcare services, and so the Department of Health used the Patients' Rights Charter to uphold and promote these important rights of patients. So while we're going through this presentation, I want to just touch on a few of these rights, but we won't move on to the next slide yet, because I just want to focus on the National Patients' Rights Charter for a minute. And Brad, maybe you could add some things here as well. But a few of these highlights are the right to have a healthy and safe environment to ensure mental health and well-being, the right to take part in deciding on matters affecting one's health, the right to treatment, to counseling without discrimination or intimidation, the right to have health information produced in one's language of choice. And of course, the important one, confidentiality and privacy concerning healthcare issues. Now, how do we think that we're going to be able to give effect to these rights under the National Patients' Rights Charter if we aren't careful as to how we process patient information? Brad, do you want to add anything on that?
No, I think for those of you that don't know, and a little bit of orientation, the Health Professions Council of South Africa's Ethical Guidelines Chapter 3 includes the National Patient Rights Charter. And it's an important charter for us. I think as we've gone through the years, not paid enough attention to it. And it's one of those kind of documents that you almost want to have printed out in your rooms to remind the patient of what their responsibility is, as well as remind us what ours are. Because in duties and obligations in the charter, not only does the patient have the rights to privacy and access to care and remediation, they also have the obligations on what they need to participate in, what information they need to share with you. So part of POPI is about collecting the right data at the right time and using it in the right way. But patients also need to know that part of POPI is them giving you not only the permission for you to hold and manage their data, but for also to make sure that they're giving you the accurate and right data. And so I don't want you to think as we go through this act and into the next few years of POPI that this is only an onerous stick to whip us with. It also is a vehicle for us to make sure that we not only are diligent, but that people who engage with us are also diligent. Jackie, back to you.
Thanks. So the other legislation and existing guidelines that I was chatting about and referring to earlier were, for example, the HPCSA booklets. We've given you a link here where you can download these important booklets. Brad and I have extracted booklets 1, 2, 3, 4, 5, and 9, where specific issues come up where you need to consider these, as well as the HPCSA Code of Ethics, and specifically focusing on pages 4 to 8.
Jackie, before you carry on, there's a question that's come through. I see Lani's beat me to it. Go there, Lani.
No, I just wanted to say I posted those 2 links for the HPCSA and the Allied HPCSA booklets and Code of Ethics in the chat functionality if people want to copy and paste it from there. Sorry, Brad. I'll answer the question. That's fine.
Okay, great. So I'm not sure if everyone can see the question, but I'll read it out in short. It says, no longer in practice for a number of years, still registered with the HPCSA, now only making use of video and footage of patients in case studies when teaching. These footage stretch over 30 years of practice life. At the time of footage taken, the patients were all informed and permission was going to use them for training purposes. No way, but no way near the scale now required. What is the impact of POPI for the use? I think there's two things that come in here. If you're using something for the purpose of which it was gained, and you've got permission for that use, that permission is sufficient. If you start using that information in a way outside of the permission that you gained, you need to seek additional permission. And we see this not only in this case, and thank you for the question, not only in terms of video footage of using someone, but sometimes we gain information, we take genetic material, we take blood samples, we do any other kind of investigation, and then we keep that information and I say to Jackie, I'm going to use this only for your clinical work. And I only use it for clinical, but then I've got an opportunity to write a case study, and then suddenly this becomes something much broader. I need to make sure now, and that's part of the reason for POPI, is that if I'm using, or if you're using information that you've gathered for one purpose, if you're using it for a different purpose entirely, you need to go back and get consent. So for this practitioner, if you're using this in the way that consent was given, then you're fine. If you use this for something else, and you sell it on and you commercialize it, and there's a potential for this person to be identified, and there's potential for their dignity to be in any way affronted, then you need to be a little bit more careful. Jackie, back to you.
Thanks. We can just go to the next slide.
Sure.
So let's look at the preamble for a moment. The fundamental purposes of POPI are disclosed in the first two phrases of the preamble, and they deal with protection of personal information. Okay, we need to introduce certain conditions to establish minimum requirements for the processing of information. The POPI Act provides for the establishment of an information regulator to exercise certain powers to perform and to carry out its functions and duties in terms of this act. And we'll get to that a bit later about what he does and how you can have access to the information regulator and when you need to have access to him or her. The regulator will provide for the issuing of codes of conduct, which haven't been released as yet, but will be. And POPI needs to provide for the rights of persons regarding unsolicited electronic communications, which we'll also discuss in a bit, and generally the regulation of flow of personal information across the borders of South Africa. Next. So Brad, this was actually your slide. We've extracted a bit of information which we're going to touch on, those relating to healthcare.
Okay, so the whole discussion that comes up is what is special or protected information? And in this case, there is a very clear set of information as it's laid out, and you can see it here. So we've spoken a little bit about it: age, race, gender, state of pregnancy, marital status, ethnicity or social origin, your color, your sexual orientation, and I want to talk about that briefly. Now, this is the extraction that you're reading here. This is not my interpretation. So this list is a list that you can access when you go and you download the POPI Act. So everything to do with a person is regarded as personal information, including then where they studied, what their medical history is, their financial, their criminal, their employment, their homeowner records, any ID number, which includes your IP address, or any way that you're assigning something to a person. Their biometric information, their genetic information, all includes that. And with that, additionally, now, and I've separated this deliberately into these two parts, because the first part we think about. The second thing is any personal information or view or preference of an individual is also part of their personal information, and it also falls under POPI. Now, I say that because I don't know about your medical records, but if you're using an electronic medical record system that's contemporary and it has a global link to it, it will ask you not only the sex of your patient, and there's now 11 different descriptors of sex. It also asks you how the patient identifies themselves. So when we start looking at personal opinions, views, and preferences, the way a person identifies with themselves is also considered to be personal information. And then personal information also includes what you think about me. If you write after this and you write to Lonnie and you say, Brad, blah, 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 good or bad, Lonnie has to treat that as personal information and store it and keep it in a way that is sensitive, because this is part of my sensitive information. So when you write your clinical notes, and well, let's start at your intake form. Your intake form information, your consent form information, the financial and billing information of the patient, their preferences of paying. If the patient is a minor, which parent is paying and which parent will be escorting them. Those all become parts of personal information. Then if I have an opinion about you, that also isn't captured in this. And this is where issues now on social media become a more difficult thing. Because if you have access to a patient's Pinterest site or LinkedIn site, or what are the others, Instagram site or Facebook site, any social media site information that you access, you now need to protect in terms of POPI, in terms of how you engage it onto clinical sites. So anywhere that the name of the person appears and where using the name of the person would indicate that that person was a participant or was a subscriber or was a willing attendee, in all of those cases, you need to understand that that becomes part of this. So if you host a talk in your rooms, or you give a talk on endocrinology or the psychosomatic conditions relating to anxiety and mental health as a result of COVID, and you record those people's names, that's personal information too. Lonnie, there are some questions which have come through here.
I see. Brad, I'm not sure whether we need to answer them. I know Jackie is trying to answer some of them. Otherwise, what we can do is compile a list of all the questions and answer it after the webinar and then circulate to all. I've got no problem doing that too.
Okay, let's see what we don't answer during the discussion. Jackie, I'm handing back to you.
Thanks. Right, so let's just walk through some of the definitions in POPI, and we've only extracted the important ones, obviously, because of time, and we don't want to go through the entire act. But basically, data subjects in your field would be the patient and or staff members as well, anybody whom information relates to. Responsible party would be yourself, the practice, which determines the purpose and the means of processing the information. Operator would be anybody who processes information on your behalf for you, for the practice, such as practice staff, employees, or third-party practice administrators, so your practice management companies. Processing, goes without saying, means working with personal information and includes the collection, receipts, recording, organization of it, collation of it, storage, updating, modification, retrieval. So there is quite a lot of duties which your practice management organizations would do. They would deal with a lot of processing. Right, and record, obviously meaning any form of medium, which again we will discuss later, in electronic copies, hard copies, etc., etc.
So Jackie, just to a point here, if you have an electronic record keeping system, that record keeping system, if it's stored in the cloud, you have a relationship with the data managers and the information officer of that company that's managing your records. If you're managing your own records, either by pen and paper or they're on your own system, you're then obligated to make sure that you've got password protection, that you've got backups of that information, and that you've taken, and we go through this often, but I'm going to say it again now, the reasonable precautions to protect that information. You can't ever stop somebody sawing through your window and climbing through and stealing your laptop. But if your laptop didn't have a password attached to it, then you have some difficulties. Just to Jackie and Lonnie, you're both muted, hey?
Yes. No, we're allowing you to speak. Okay, you can flip to the next one. Right, so basically POPI considers a patient's personal information, to be precious goods, and therefore bestows upon the patient certain rights of protection. And as we discussed earlier, and I'll just briefly touch on again, it's how the patient chooses to share his information. Obviously, there are limits to this, but if the patient consents to you storing information, and consent is an ongoing thing with practitioners such as yourselves, there would be no problem there. The patient doesn't have automatic rights to dictate to you how to delete your information, because you are obviously bound by statutory provisions which say how long you must keep records for. So the patient has limited rights in that regard. However, they can request you to update any incorrect information, misleading information, or inaccurate information. So again, the patient would be able to ask you how you store your information, and he or she may require access to his or her own information. So you need to be able to be accountable and advise the patient how you are doing this. You must have adequate measures and controls in place to prevent unauthorized access to patient information. And we'll go through some examples just now of how you can do this, but some, just to touch on a few, would be: don't leave patient information laying around on a counter when you have a room full of patients and you know patients are going to be presenting at the desks. With inquiries with the receptionist, have the file perhaps on the desk of the receptionist as opposed to on the counter. At all stops, you need to ensure that other patients do not come into contact with patient information.
Yeah,
all right.
And sorry, Jackie, if I can, examples of this, and you'll know this from your rooms, sometimes you would leave the path results in a file by your receptionist's desk. That's now in breach of POPI. If I can come to the desk and I can look over and I can read it upside down, you're in breach of POPI. There are some questions that we've had. What happens if a patient says, I want you to delete me off your system? Well, your answer is fine. I can delete you off my communication and correspondence system, but I have to still keep your clinical records for a minimum period of time. And Jackie will tell you a bit about that later. So there is a difference between removing a patient's demographic information off your communication system, and that's different from what you do with the storing of their clinical and financial information. Here you go, Jackie. You're still on mute.
Thanks, Brad. So we touched on a bit earlier about do patients have all these rights to information? No. With all rights in the Constitution, they may be limited, provided that the limitation which you place on them is justifiable and reasonable. This means you must be able to act reasonably, and you must be able to justify why you cannot release the records, or why you cannot give records to a certain third party, or why a party cannot see or alter their records. And we said earlier that the HPCSA guidelines and legislation require you to store information for minimum periods, and so by law you cannot be asked to delete these before the prescribed time. Okay,
Jackie, if I may
so
ask you a quick
yes,
question. This is something that came in. It's communication with medical schemes. I mean, if you need to obtain authorization, let's say for a surgical procedure, from a medical aid, can you do that? Because you obviously need to share some of that personal information of the patient with the scheme.
Yes, correct, Lani. So that's why we always recommend that you put those kinds of consents that you require in your consent form, that you will need to share ICD coding and or diagnostic codes with medical schemes. So in order to ensure that you can actually legally pass that information over, and to the extent of what the information is, you need to ensure that your consent forms are very watertight and provide for all of this consent. So I think everybody's going to need to, after this, revise their consent form in some way or another to ensure that all parts of POPI are complied with.
And just in saying that, while we're talking about that, I mean, the way that you communicate with the medical schemes, usually you would email that information. Now, can you use a normal Gmail or a Yahoo account, or do you actually need a paid account? Is it safe to use a Gmail account, for example?
Look, you should always ensure that if you do need to send information, that your emails are encrypted, and that your emails are hosted by a web company that services you well, and you have an SLA with that regulates how information will be stored, if it won't be stored on any local server, but on a web hosting server. So those are the kind of things you need to find out from your service providers.
Okay.
Can I make a comment there as well? Lani, is that okay?
Of course. Yeah.
I do think that you mentioned specifically Gmail or any of these other groups. Google and Yahoo and Amazon and others have a tremendous attention to the management of their user data, which is yours. I think that the issue here is use what you always use, but make sure to separate what you do in your personal life from what you do in your practice life. If you have a bradfun@gmail.co.za account, don't send your patient information on your Brad Fun account where you also send your dog and your social and your running information to. Keep them separate. If you have a social laptop, don't keep or a work laptop from another initiative that's not your clinical stuff. Don't blend the two together. Keep your work and your clinical and your patient-related things separate. It's unique. You don't treat your patients in your lounge. Don't bring them into your digital and social lounge.
True. True. Jackie, you mentioned consent forms, and I just want to mention to the audience today on the webinar that if you're a ProfNet member or a SPECIFICATION member, all our consent forms will be POPI compliant as from the 1st of July, and you can access on the member portal. Anyone here not a member yet, at the end of the webinar, we'll share some information. If you require any details, please contact us. There's a ProfNet and a SPECIFICATION link. We can easily sign you up as a member, and you can also get access to magnificent details, documents, and everything. They will be POPI compliant. Sorry, Jax, I interrupted you.
No problem. No problem. So, right, we were talking about whether patients' rights can be limited. If you can prove that the privacy of the communication or the personal information is within your care justifiably, then there's no problem there. You need to be able to, however, prove that the ability to store the information versus the taking away from the rights of the patient to confidentiality is justified. Okay, so you need to have a look at the relationship between the limitation and obviously its purpose. And these two are always closely related. And there may not, in your instances, be any less restrictive means to achieve the purpose because of the fact that you need this healthcare information in order to correctly evaluate, diagnose, and treat the patient. All right, Brad. Going to leave. So with POPI, and I think we're getting away from the issue a little bit because we're getting into some chats, but essentially we wanted to today move you through the 8 requirements of POPI so that you can see what it is that you need to do. These are 8 considerations that need to be made within a person's business or practice in order to comply. So starting with the first one, we already know. Brad? Already know that everyone needs to have accountability. Okay, this means that POPI has implications for medical practitioners, and POPI does affect you because you process information such as names, addresses, email addresses, and of course health information, and in some instances employment details.
Can I just weigh in here? This also includes on accountability. If you're referring a patient and you're sharing information out, or you're looking for authorization or pre-auth or any sort of permission to extend care, the same principles apply. You wouldn't simply give somebody a patient's information on a referral letter to somebody without saying to that patient, Lani, I'm referring you to Jackie, or I'd like to refer you to Jackie, or say to the patient, I need to get authorization or pre-auth or extension of treatment permission in order to facilitate your extended care. So this is where some of that accountability continues. Jackie.
Jax, you're on mute.
Sorry. Moving on to the next requirement. Can you hear me? Sorry, a bit of a lag there. Moving on to the next requirement, processing of information. Can you hear me?
Yes, yes.
Okay. So you are only allowed to use information for a primary purpose. You may not use it for any other purpose. And an example of secondary purpose would be for your own amusement. Okay, so the idea here is to only store what you need to store and nothing after that. This includes preventing the disclosure or transfer of personal information to third parties, and we used the reception desk as an example earlier. The biggest liability in any system is obviously the individuals using it. So again, referring to the staff member at the desk where they could put that information in front of them in front of their desk rather than on the reception counter. So we have to look at things such as staff, practice management companies. They need data in order to complete their duties, but it's about how they use their data and how they keep the data secure that matters. All right. So then the next thing is purpose specification. The key elements of this, obviously, you collect it for a specific purpose. So in order to test a patient or diagnose a patient, and then the HPCSA guidelines as well as legislation will then determine how long you may retain those records for and whether there's any restriction on that. You may, in some instances, not have seen a patient for a prolonged period of time, in which case you may wish to archive the documentation at half the retention period. In other instances, you may prefer to do so at exactly the time of what's prescribed, for example, 6 years from the last time the record became dormant. So whatever you decide to do, you need to just make sure that you have a good system in place and that this is documented well within your practice so that everybody in the practice knows how to deal with documentation when it is to be archived or when it is to be retained. Right, Brad, next slide. So I was going to leave this to you because this is your speciality, but essentially, as we've been discussing the whole day, is that minimum prescribed periods exist for retention of records, and these are set out in front of you here.
Yeah, I'd like to weigh in. I'm almost at my word count. So for all of you who haven't heard me before, Lani and Jackie give me a word count that I'm not allowed to speak more in any given presentation. I think the important thing here is recognizing that the records kept from minimum after the last time you saw that patient. So that's 6 years after the last time you saw that patient. 21 if it's a minor, indefinitely if it's a person who's incapacitated. If you work in health and safety, or you work in OC Health, or you work as part of a employer integrated team, you have to keep those records for a minimum of 20 years. Because that's the COID requirements. So retention periods may vary, and you should also extend them. If you've got a matter where there's a notification or a potential claim, keep those records for longer. If you have a family and you're treating the child and you've seen the parent once or twice, it might be 6 or more years since you've seen that parent, but you know that the children still have 12 years before they become adults. You may want to keep those records for posterity. Also, because in certain instances, you'll know you want to go back to your records. Hopefully they're legible and complete enough to do that. But if you've got active family, keep them for as long as the family plus 6 years. So that's the prescribed time. If you're working for an employer, not only do you have to keep it for as long as the person is employed, but if there is a resulted IOD complaint or any matter that relates to impairment, incapacity, or temporary or permanent disability that does lead to dismissal, and you're involved, you need to keep it for that period of time as well.
It really does sound as if we need to move away from paper records, because that's just going to become a big pile of records after 5, 6, 7 years, even 21 years. So
yeah.
try and go the electronic route. Use practice management systems like EZMed or VeriClaim and store your records online.
Correct, and the world has changed. I know now if I need to see an image or an x-ray or an investigation, I can go online and use a PACS and I can see it. And so what you've got to also bear in mind is anytime you're using these, you need to say probably in your intake form and your current consent that you will be, with their knowing permission now, accessing their information that's clinical information from other providers, as the case may be or as is needed, because you just can't get away from that. And so you don't need consent each time you do something, but if you're part of an interdisciplinary team, make sure that all of you have either a shared consent, or that if you're working in the same practice number, you still need to manage consent and manage POPI as if this was your patient, because it is your patient. And it doesn't matter. Sorry?
No, thanks for answering that question, because I see someone did ask about multidisciplinary teams.
Yeah, because then what happens in a litigation, they say, well, who is the who's the initial clinician here? And then everyone points fingers in different directions.
All right, we better crack on. I'm watching the time.
Jackie, back to you. You're muted again.
Sorry about that. I'm trying to answer questions as well as do the presentation at the same time, multitasking. Right, so conditions for lawful processing. We said earlier that you must take steps to ensure that the data subject is aware of the purpose for which this information is being collected, and this can also be set out in the consent form. So as I said to you, the consent form can be changed to make it more watertight as to how you want to let your patient know where its records are being kept. I have seen some consent forms come across my desk where people actually put the practice management company in the consent form, saying that this is where your records will be stored, and should you have any issue with us sharing this information, please let us know. But that we need to be able to share it for purposes of treating you effectively, and because this practice management company handles my practice queries so that I can practice more efficiently. So again, if you want to share that information, you are more than welcome to do so in your consent form. However, so long as you have answers to questions when patients present with these questions, then I also think that is also fine. All right, next slide.
Getting there.
So information quality is important because one can't treat a patient if you don't have correct information. And I've also seen some consent forms that say, you know, we rely heavily on the information that you provide to us, and that your any misleading information or errors might result in hazard to you or not being treated effectively. So again, you know, as much as you can put in your consent form, the better for you. But again, if you're asking me outright, I would say the information quality is best obtained from the patient, the person you're treating, obviously without question here.
I think one thing here as well, you know, we say we take great notes, but I know we don't. Mm-hmm. I know we don't, because I have sometimes the trauma of reading them, and Jackie does also, when it comes time to reviewing. So you'll see there, you must take reasonably practical steps, and reasonably practical steps is the key phrase. If you took one thing out of here from today, it's reasonably practical steps. You take reasonable practical steps to get and elicit the information from your patient. That's a piece of information quality. You take reasonably practical steps to record that information on your record system, whether it's pen and paper or digital. Then you take reasonably practicable steps to store that information. If somebody comes in and they steal your laptop, or they put a virus or a worm in, that's beyond reasonable practical steps. And then your reasonable practical steps is how you recover that information, or how you retrieve it, and how you notify people of a breach. So we may get to talk about that later. Maybe that's for a different day. Jackie, that's your openness slide. You're muted again.
Yep. Right, so we have these obligations under section 14 and 51 of POPI to be open with the information that we store. The data subject, the patient, has to be aware of the collection of his information, the source where it was collected. So someone asked on the chat functionality just now, what happens if I refer a patient? Well, you would discuss this with the patient verbally, and you would provide them with a written referral note. And so they would be made aware of where their medical information is to go, and you are authorized to share this with any treating professionals. Okay. They are entitled to know the name of your practice, and the address where you're practicing. So, I mean, this goes without saying, we all do things on letterheads, so no problems there. And you would then need to tell them the purpose for which the information has been collected, the law authorizing the collection. So then you would refer to the HPCSA guidelines and or other legislation, and how you intend to transfer the information, and back to, say, for example, the referral situation, or the situation where you're sharing it with medical schemes, which again can be made relevant and noted for the patient on the consent form. So a lot of the time I have suggested to some medical practitioners that they should try and put a disclaimer on their emails that say that we collect information for this purpose. We will do our very best to protect the information. We have the necessary safeguards in place in order to protect it. And then just finalizing that if you have any complaints in this regard, or you wish to make any changes to your information, you can contact the practice, giving them all these opportunities in which to correct any information should they so wish. So how you can secure patients' data is by taking some steps, and these would include having a technical and organizational method. So those who operate largely on email would have different requirements, say from a therapist who might communicate with patients largely via WhatsApp. And of course, those differently from practitioners that still use a very largely manual filing system. So this would include software protection, ensuring that you have passwords on all devices, that you don't distribute or circulate information with others unnecessarily, unless it's for, referral or multiple treating practitioners. You shouldn't have a no USB or flash drive company policy so that staff are not able to take patient data home with them when leaving the offices. You should train your employees on POPI offences to make them aware of disciplinary action should they not comply. You should also ensure that you have confidentiality clauses within your employment agreement so that staff are fully aware, within the practice that you operate, that things are very, very confidential when it comes to patient information. So we chatted earlier about, under the National Patient Charter, patients having a right to participate in their healthcare. And we also said that this could be limited in some instances where they're asking you to, delete data before the time periods are up. But again, the responsible party, so long as you can confirm that you hold information about the data subject and you explain to them the reason why you hold this information, which most of the time they're going to understand because this is why they've engaged you. They may also be aware of their rights and how to request the information. So a lot of the time this isn't as clear. We don't always say to patients, hey, if you want your records, you can just make a written request. We kind of wait until that happens. But again, so long as patients are made aware of how they can do it, and you could have perhaps a notice up in your practice somewhere saying how they go about either lodging a complaint or getting access to their information to make this easier for them. All right. So now the big question of the appointment of the information officer. I see from some recent news media which we've received off the regulator's website that they've extended this date even further. So don't panic. It was 1 July, but I see that they are looking to move that a little bit later. The final date was still to be released. But essentially, I would recommend that if it is a sole practice that you are running, that you go and register with the regulator as the information officer. And obviously those practices which are larger and have more than one practitioner working there, that you designate a information officer as well as a deputy. These people should be selected from individuals that know the business well, that understand how they operate and understand the significance of breaches should a breach occur.
It takes about 3 minutes to register.
It does.
We'll share the link with you.
Done.
Okay, the link's been shared below. So basically, this person that you've designated within the practice to report breaches to the regulator would do so once they come across a breach. Now, Brad and I were just chatting this week about what actually constitutes a reporting of breaches just yet. So that may take a while to do. But I wanted to just say that I think a breach would be a huge thing rather than say the small things. Perhaps a breach of multiple patient information at this stage would be considered something quite serious. Loss of all files from a cabinet, loss of very, very important records needed to treat the patient, etc. Brad, maybe you could shed some examples as well, because one of the famous things that we see happening a lot is where you have several people on an email that you're perhaps providing advice to, and one person that you've included on the email incorrectly receives the email and says, hi, excuse me, I don't think I was supposed to be included on this communication, and then sends that back to everybody else. And that's the famous one where now you've become aware that everybody else has received this information that they ought not to have received. So, we need to be careful about that, selecting the correct party that we need to for the communication.
Yeah.
Brad, over
Becky,
to you.
can I just answer. There's one thing that keeps coming up, and I want everyone to be aware of it. What you do in the normal course of your day, by contacting people who've given you contact details if you need to contact them because of a missed appointment or a reminder or a follow-up or a referral that you're sending for an image or a scan, or you contact a colleague because you want to find out how a mutual patient is doing. That's all in the normal course of things. None of that breaches POPI. It's where and bear in mind, if you put the name of me as your colleague and my number is there, we used to have these things called telephone books that have all of the details and information there. We're not talking about publicly accessible information in the normal course of business. We're talking about proprietary information that's unique to that person, that's used in a way that could profile or prejudice that person. So if you're doing, for example, a submission to a colleague, or somebody asks you for a referral letter or a endorsement of who they are, and you put my and Jackie's names on, that's not a breach of POPI. Generally, as a courtesy, you would say, I'm going to use Brad's details. I'm going to give him a call and say, Brad, can I use you as a recommendation for my son, my daughter, my colleague, myself, whatever the case may be. So let's separate out what you would do in the normal course of follow-up to communicate a patient's state of health with them or another, or to usually run your practice, with the combining of multiple patients' information in a way so that you can sell your practice, or that you can allow a company to market to them and try and sell their goods to your patient base, which used to happen in the past. I know it happens a lot less now. Jackie, I'm handing back to you.
Just unmute yourself, Jax. Jackie, we can't hear you.
Okay, so while Jackie's muted and doing stuff, the site to register as an information officer is not online at the moment. It's glitchy, and that's why they've extended the deadline. So if those of you who have taken the link now over the past couple of weeks have tried to do it, you may find that either it tells you your ID number is already there, in which case you can't re-register twice. And in many cases, they've pulled ID numbers of people who've been compliance officers or information officers. For example, me, I can't register myself again because I'm already registered somewhere else on the Department of Justice system. So don't fret about that for now. I think more for now, as we've gone through this, is be aware that your conduct relates to very much what you've already been doing and how you communicate. Jackie, you're back, so I'm going to hand back to you. Lonnie, I'm aware that we're wrapping down on time.
Yes. Right, so I just extracted a few questions which we've been asked this week. I thought we could just go through these few. Is my use justified? Well, we said earlier that yes, processing by healthcare practitioners is going to be necessary to pursue the legitimate interests of the patients, and that is to treat them optimally and efficiently. Can a patient object to me processing information? To a degree, only where they are trying to correct inaccurate information, or the information is excessive, or it is possibly outdated, irrelevant, or the practitioner is no longer to require it. So you may get some very clever patients who say, the last time I saw you was 8.5 years ago. Do you still have my records, and test you? You would need to make sure that you are going through those cabinets and seeing when last your interaction was with patients, and having your receptionist or staff assist you with that destruction, and having a proper protocol in place for what information you collected, how it was destroyed, and when it was destroyed, and if it was timeously destroyed. All right. Must I appoint an information officer? Yes, as a responsible party under POPI, you need to register. Okay, and we've referred you to that definition. Will I get into trouble? And this is what I was chatting about earlier, is that developments ahead of the enforcement powers have said that the information regulator has confirmed that there will be no deadline for registration of information officers and deputy officers. This means that you will not get into trouble if you haven't registered by the 30th of June. And I hope that helps you. If you have any questions during the course of the week, or anybody feels nervous or unearthed by POPI, please don't hesitate to contact Brad or myself, and we will send you and or consider any of your queries and best help you where we can.
Definitely, and we'll share that contact details in just a second. Before we wrap up, and I'm going to go back to both our guest speakers just for a final word, just some more information. I'm sure the majority of the healthcare providers joining us today are aware of the PIA manual, and you might even have one. Now, the PIA manual must now include information that relates to the processing of the personal information by a private body, considering yourself a private body. And these amendments apply as well for the 1st of July. So we're very happy to inform you that both ProfNet and SPECIFICATION has partnered with a company called ComplyMed. And they developed an online process which allows you as a private body, a healthcare professional, to generate a fully compliant PIA manual in a very short but a dedicated space of time. So if you are interested, I'm going to share the links with you in just a moment. Copy the links, paste it, and just follow the prompts through there, and it will absolutely guide you through that process and help you to become fully compliant. But we do need to start wrapping up. While I am posting the links in the chat functionality, I just want to say I sincerely hope that everyone here receives some valuable information this afternoon, that you're going to take at least a little bit of information that you didn't know already back home to your practice and try and apply that. Just quickly, if you are a medical, or if you have your medical professional indemnity or your MPI with Genoa and Shackleton, please free to contact both of them. We'll share the information. Or even if you just want more information about the POPI or become an MPI member with them, if you want the insurance with them, please contact them. Jackie and the rest of the team is extremely helpful and great at answering emails. Otherwise, best advice is to go to your own legal advisor for assistance and guidance on how to become fully POPI compliant. I would also just like to inform the attendees, like I did before, for both ProfNet and SPECIFICATION members and those who want to become members, all of our documents, all of our agreements and our systems will be fully POPI compliant come the 1st of July. So if you remember, you can log into the member portal and access those documents in absolutely no time. And if you want to become a member and really get some of those beautiful and functionalities and benefits from both ProfNet and SPECIFICATION, please go to your emails and pop us an email and we will gladly get back to you. I'm just going to copy all the links now at the moment. I'll post it in the chat functionality, but perhaps Jackie, just a quick last word from you, and then we're going to hand over to Brad to finish off. Thank you. Brad, maybe you can start because I think, oh, there we go. Jax, over to you.
Yes, no, I don't really have any other concluding remarks other than we are here to take your questions. And thank you so much for the opportunity to address you on this, and keep the questions coming.
Absolutely, absolutely. And I just shared all the details with you. You can copy and paste that. It is in the chat functionality. Brad, a last word from you.
Yeah, firstly, Lonnie, Jackie, thank you so much. And to everyone who's listened and asked questions, thank you all so much. I want to just draw one closing distinction. There is a distinction between the compliance of POPI, which is how you store and process your data, with maintaining confidentiality, disclosure, informed consent, and managing yourself on social media. So a lot of these questions relate to your ethical and clinical obligations as they are with the HPCSA or AHPCSA. That remains unchanged. How you record, how you get consent, your frequency of consent, your mechanisms for disclosure with divorced parents, your mechanism of getting consent from minors, and how you manage your practices are consistent with many lectures that I know that ProfNet has given you and that Genoa, that Jackie and I have done. So stay true to what you need to be doing in terms of the National Health Act, your Health Professions Act, and your regulation with your statutory body. Bear that in mind. POPI doesn't change any of that.
Lani,
Jackie?
just to correct Brad. Lani, just the last one. We do have that risk questionnaire. Now, it's not designed to make you POPI compliant. It doesn't give you a certificate because, you know, POPI is an ongoing process that you'll have to comply with. But what we do have on hand for you is a short risk questionnaire, which you can fill out, and that can help you ascertain what areas your practice may be falling short in so far as POPI's compliance is concerned. and it'll give you some food for thought. So you don't have to complete it and return it to us, but it is a nice little concise version of what you need to do and what you need to focus on.
That risk questionnaire being available if you email Genoa, ProfNet or SpaceNet. We will happily send that over to you. That is all the time that we have got. First of all, Brad, Jackie, thank you very much. I think it was a very, very interesting afternoon. I'm sure everyone benefited from this. It is unfortunately all from us, folks. Thank you so much for attending. I think there was an immense registration to this webinar. We might need to do this one again if you don't mind. But do keep an eye out for our future webinars. We will, like I said at the start, send out communication to everyone attending and for those that registered. And this webinar will be made available on our YouTube site, which I have shared the link for. Good luck from my side with all things POPI, and don't just keep your own and other people's information safe, but also stay safe, stay healthy, and be kind to one another. Have a great evening, everyone, and good night.